welcome again. I'm hoping that this will be the last video referencing Professor Anne Toomey's seditious denouncing of the principles underlying constitutional law in the British Commonwealth. I'm not expecting her to respond to my offer of a debate on this, especially as she has now been placed on notice for treason, misprision of treason and sedition, citing irrefutable evidence for these charges. But one never knows. However, there was a lively thread of comments and responses to her video of late July. Some of those which were critical of her analysis or stance were deleted, and others were subjected to argument from those who supported her position or views. One of these in particular, styling himself Oz Pseudo-Law, took up the cudgels, metaphorically speaking, although it seems he isn't averse to actually using cudgels as a means of settling disagreements about law. Certainly, his comments reflect a vehement support of the current legal and judicial system, which is, of course, based on the use of force or violence, should anyone be audacious enough to want to argue lawful moral principles in any of our fake corporate courts. Oz Pseudo-Law, or to give him his published name, Robert Sudi, is a researcher of law and claims to have, quote, authored a legal encyclopedia so accurate it is referenced in the law journals of 4 nations, end quote. Robert Sudi has a YouTube channel named Oz Pseudo-Law because it's devoted to debunking some of the arguments put forward by members of the so-called freedom movement. Robert gives wholehearted support to the current legal system as entirely legitimate and the only viable means of resolving disputes between individuals or between individuals and government agencies. Those in the legal profession, the judiciary and politicians, of course love it when such contrived distinctions are accepted at face value by the populace, because failure to analyse the errors in such distinctions blinds people to the fact that in reality there is no objective difference between a dispute between 2 individuals and a dispute between 1 individual and an alleged government agency. They are one and the same. The legal profession has spent 800 years trying to inculcate such false dichotomies into the public mind, seeking to get recognition from the masses that if the government or someone involved in the law has a disagreement with an individual, that the opinion of the official carries extra weight because it has the tacit support of the community. They will usually allege that this is because the system has been voted upon, and if one doesn't like it, one is free to enter the political sphere and get amendments voted into the existing rules. The fact, however, is that under natural and constitutional law, as specified in Magna Carta 1215, every individual is responsible and answerable for their own actions. It's obvious nonsense to claim that some people have the right to aggress against others simply because someone else gave them an order to do so. The principle has been part of natural law for millennia and was established, although superfluously, even in international and statute law after World War II at Nuremberg. And there is another of those logical fallacies that Robert Sudi claims to be able to point out in others, but fails completely to see in his own utterances, that voting somehow changes the laws of nature, and that if enough people concur with something, such as the granting of power to certain people by virtue of their job titles to be able to aggress against others, then society as a whole may carelessly violate the natural law of do no harm with impunity. Let's have a look at some of Robert's own statements. I don't want to be accused of misrepresenting him or his position. Starting with his response to my stating that I was going to be doing a video in response to Professor Toomey, and pointing to my Locked On Article 61 series on YouTube, Rumble, Telegram and elsewhere, quote, "If only overturning the binding decisions of the High Court was as easy as ranting on a video," end quote. My reply that the decisions of the High Court, being bereft of moral considerations and only backed up by the use of force, imposed no more moral obligation to obedience than the decisions of any other body which were sustained only by force. For example, those of a criminal gang, was deleted, and Mr. Suddy responded thus, quote, "I don't give a shit if the decisions of the High Court are morally binding in your opinion. The question is whether the premise is workable within this legal system, which it provably is not. I don't need to join your cult to disregard law, been around the criminal element most of my life," end quote. He's clearly well qualified to utter that last sentence. And he's correct in stating that the premise of law being based on moral principles is provably not workable within the current system. The two are inimical. Either one will inevitably destroy the other. My response was, quote, "Is it not worth attempting to reform a system obviously based upon force, which openly places people into superior and inferior classes as regards rights? Many feel it is. And I'm not throwing a tantrum, I'm constructing reasoned arguments, so get over it," end quote. Robert responded, quote, "The way the law is has nothing to do with me. You aren't presenting reasoned arguments. You are ranting your misconceived opinions. To be reasonable, you would first have to acknowledge reality the way it is before you attempt to change anything," end quote. Robert continued, quote, "What I don't base it on, as you do, is an ideology, a belief system based on a long obsolete document. I look at the way things are, not how I wish they were. I have the serenity to accept that when it comes to law, the final arbiter is the High Court, not some random bloke ranting on a YouTube channel," end quote. Here, Robert adopts the viewpoint of the legal positivists discussed in video 74, The Philosophy of Law. Their first tenet is that we should focus on what the law is, not what it should be. And if it's bad law, we should do what, Robert? Nothing? What about laws sanctioned by the High Court that led to such atrocities as the stolen generations? Their second tenet is law is created by human beings and is therefore a social contract. A contract requires explicit consent, doesn't it, Robert? What if the proposed laws are not morally acceptable to some elements of the community or individuals? They just get cudgeled into obedience, do they? What sort of contract is that, Robert? Thirdly, they are content that there be no necessary connection between law and morality. So how do legal positivists deal with the uprising of tyrants, which is inevitable over time, Robert? Just shrug their shoulders and say, oh well, the smart ones will simply wheedle their way into law or politics and protect themselves, and the devil take the hindmost. Is that how you see it, Mr. Sudi? My response to that excuse for an argument was this, quote, "Speaking of logical fallacies, isn't it one to pay more attention to the credentials or social status of a debater than the cogency of their arguments? Is it not more important whether they speak the truth than who they are? And don't kid yourself that you're not a believer in some ideology. In your case, it's called statism or collectivism, and it's based upon principles that are seriously contradictory and unsustainable in nature," end quote. Robert then goes on to accuse me of engaging in circular reasoning and not citing any law, despite the fact that I refer several times in the thread to Magna Carta 1215, especially Article 61. At one point, Robert uses the sentence, "That's like saying the Bible is true because it says so right here in the Bible." My response to this type of positivist nonsense was, in this case, you're attacking my position by stating that I'm not qualified enough to be taken seriously, but you're not addressing the arguments. Instead, you're deleting them. You accuse me of making circular arguments and not citing any law, when in fact I'm referencing the earliest written iteration of common law, which is Magna Carta 1215, which stands in perpetuity. You can read that for yourself in Article 61. And contrary to Professor Toomey's statements, constitutional law overrides statute law, not the reverse. It's you who are making circular arguments by saying, in effect, The law as we say it stands is the law because it's as we, the legal profession, has made it. You're using your own concoction of rules as justification for itself, which is circular nonsense. Where is your Grundnorm, the ultimate behaviourable norm, acceptable by the entire community as the basis for justice, backed up by the system of trial by jury? It is Magna Carta 1215, but you're afraid to go back that far, as it exposes the fact that your contrived system of legality is based upon deception, manipulation, and enforcement by violence. You have to lie to pretend that a constitutional principle or law can be amended by any group capable of sustaining its changes by force. As such, it is utterly invalid according to principles of natural law and justice." End quote. It is, of course, also the crime of sedition to publicly undermine the Constitution, especially in writing. Robert Soudy's primary fallacy, which he shares with Professor Toomey and the rest of the legal profession, is their constant conflating of the terms legislation and law. They like to use these words interchangeably, as though they are exact synonyms, but they are not. They are two different things, with law having the larger, more expansive definition, and legislation being subsumed within that larger definition. Legislation, broken down into its Latin roots, consists of legis, meaning law, and latum, meaning something made. It is therefore made-up law. But if there can be made-up law, there must also be law that is not made up, which exists in nature, independent of mankind. As humans are part of nature, we are also subject to natural laws. To reach our true potential, we have to abide by the laws that govern our nature. And for humans, a species with very little instinctive means of survival, that means exercising our individual thought processes and actions in a state of freedom. Those like Robert Soudy and others who contend for the privilege of compelling others to obey their will by means of legislation can never eradicate the drive towards freedom of expression in thought, word and deed of their fellow humans. They can threaten, coerce, torture, even murder those they regard as recalcitrant, but they can never force the human mind. The decisions an individual may make within their own thoughts are forever beyond the reach of the tyrant. Any attempt to force or coerce another to act against their own moral convictions or natural rights inevitably steps over the line of criminal behaviour and cannot be correctly defined as law. That is where Professor Toomey warrants being placed on notice for the crimes mentioned at the beginning of this talk, and Robert Soudy warrants the shunning of those who abide by true law. So finally, the nub of the matter, principles. My final response on the thread to Robert Soudy, quote, "Parliament didn't exist at the time of Magna Carta 1215. Parliament has no authority to delete or amend constitutional law and write itself into constitutional supremacy. That is obvious to anyone with two brain cells to rub together. If one group were able to do that, why not another, or yet another? If ultimate authority is to reside with the most heavily armed or effective fighting force, where would there be any possibility of the rule of law? One thing is certain, the rule of law can only occur when each individual's right to peacefully exist without being subject to aggressive force or fraud is upheld constitutionally, which limitation must also extend to every branch of government, especially the legislature. Knowing and being able to quote all manner of legislative bills does not make one an expert in law, my learned friend. One needs to know and accept basic principles. Principles, as the word defines itself, come first, and the whole justification for the existence of any system of law and justice is morality. There's no reason to have any laws other than to uphold commonly held principles of morality, the primary of which is do no harm. Not knowing that makes one no more erudite than a monkey examining a watch. Thank you for watching.